Yes, good evening, everyone. Thank you for taking time to join today's meeting as well. And today, thank God, today is Friday, so that you can have time to rest and have good time for yourself. So thank God, today is Friday, and I hope we are happy to be here. I hope we are happy to be here together to have great time together as we look into today's lesson. So it's a great privilege to have you to connect today's meeting as well, and we are not taking that for granted. Thank you very much for the opportunity to have you join us today. Today we'll be looking at module 5 of this training, and we'll be looking at hybrid ADR processes. Hybrid ADR processes. That's what we're looking at today. I hope that those of you that wrote emotional intelligence examination, you have gotten the instruction on what we want you to do. I hope you received the instruction on what you are expected to do. We screenshot how you are going to approach the portal to get your certificate. Also, how you can get your serial number for you to be able to generate your certificate. So, after this meeting, I said tomorrow I'll start sharing the this thing, but tomorrow I'll start sharing them tonight. And when I'm done with this meeting, I'll start sharing the serial number so that you can access your certificate. So if you don't get it today, you get it tomorrow, as the case may be. So so just follow the instructions and try as much as possible not to make mistakes. Making mistakes means that um you are putting us in a tight situation whereby you may feel bad if we deny you the opportunity of giving you the serial number again, because we don't want to give two serial numbers to anybody. So once you don't get the first one right, I may advise you kindly to rewrite the exams and take the course later on. So that's what we'll do. So try as much as possible to make sure that you don't make mistakes when we send you the serial number. Once you get your certificate, try and print it. That's it. So thank you for joining today's training. You can do way to share it with someone, invite the person to also participate and learn what is going on here for free. And then also you can as well like and comment to paraphrase what you are learning so that we can know that you are hearing and you are following what we are saying. So today, like I said, we are in module 5 and this is our day what? Is it day 15? Day 15. So by next week Saturday we'll be far. Yes, by next week Saturday we'll be far. All right. So Saturday, Sunday, Monday, we'll be done with the training. By Monday, we'll be done with the training. So we are looking at hybrid ADR processes. Hybrid ADR processes. And what are we looking at in Unit 1? We are looking at collaborative law. Collaborative law. Collaborative law. That's what we are looking at. We are looking at collaborative law. That's what we are looking at today. Collaborative law. So we are looking at the definitions and principles of collaborative law. We are looking at uh, the collaborative processes. We are also going to look at the benefits and challenges of collaborative law in family and business disputes. So we'll be looking at the definition and principles of collaborative law. We'll be looking at the collaborative processes, and we'll also look at the benefits and challenges of collaborative law in family and business disputes. So these are the things that we'll be looking at today. And tomorrow we'll look at unit 2 and then we'll continue like that. We have several units in this module to cover. So what is collaborative law? When we talk about collaborative law, as the name implies, uh, it's a kind of situation whereby the people having issues with their lawyers come together to help to resolve problems. They work together to find solutions to their problems. Do you understand? That's what we call it collaborative law. And they find it outside of the court. Do you understand? They find it the solution outside of the court. That is, the lawyers and their clients work together to provide solutions for the parties involved. Do you understand? And this always takes place outside of the court. And apart from that, it is also applicable in family laws, that is, in family issues. Do you understand? This particular law or collaborative law is specifically applicable, much applicable in family issues. Do you understand? But I have family issues like divorce and other family matters, we sharing and all those problems. Do you understand? This is where this particular law is being used. But it is under ADR because it's also one of the functions that take place outside of the court. Do you understand? So if they are not able to achieve any meaningful result in collaborative processes or law, then it can be taken to court for litigation or anything like that. Do you understand? So it is paramount we should get this right first. So someone will be asking, why are we calling it collaborative law and we are saying it's ADR? Do you understand? It's ADR because it functions outside the court. So that is why it is under ADR. Do you understand? Collaborative law. So let's look at uh, the definition properly. We say that collaborative law is a method of alternative dispute resolution where the parties involved, typically in family law cases, agree to work together to reach a settlement without going to court. Without going to court. Do you understand? They work together. That's why I call it collaborative. They work together. They collaborate to find solutions to their problem without necessarily going to court. Do you understand? And they make it a decision not to do so, not to go to court. Do you understand? So each party hires a specially trained collaborative lawyer, somebody that specializes in what family laws, someone that specializes in what family law to, you know, come to their aid. Do you understand? To come and intervene, come and you know help them to find solutions. So each party is allowed to hire a specialist in that field to help them to resolve their problem. So that is uh, collaborative law. So now, what are the principles that guide this collaborative law? What are the principles that guide the collaborative law? One principle is voluntary participation. Nobody is forced to participate. Participation is voluntary. Do you understand? So parties come into it willingly. Nobody forced them to do it. Yes, I have issues. Besides, it's a family issue. Do you understand? So we should work willingly to see how we can resolve our problem. But nobody certainly is going to force you into it. You have to find a way to come together to work your solutions and achieve results. Do you understand what you want? That is, you take steps that will guide you to your resolutions. Do you understand? So that's what we're talking about here. So, and then we talk about transparency. All right, there's also the aspect of transparency when it comes to collaborative law. Parties shall all right, parties share all relevant information and documents openly. That is, the parties to the dispute, they don't hide information to each other. Do you understand? They share information and they share it openly. Do you understand? They share documents, information openly. There's no need to hide anything. It's a family issue. Do you understand? There's no issue. So, and this can foster what trust and reduce the need for adversarial tactics. So nobody is working for the downfall of anybody, but everybody is making genuine efforts to make sure that they find a mutual solution that benefits all the parties involved. Do you understand? So that's what um that's one of the principles of collaborative love. Another principle is commitment to settlement. So once the parties find a mutually satisfactory resolution to their problem, all right, and without going to court, then they work towards making sure that that resolution is achieved and that resolution is implemented. Do you understand? So they put in effort to make sure that the right solution to their problem is identified. And of course, they work towards its implementation as well. So interdisciplinary support. What this means is that these are these are professionals who are specialized in family laws. Do you understand? But there are certain things that may require them to hire other professionals or seek the guidance and advice of other professionals to advise. Maybe the family is having issue of the issue has to do with finance. Do you understand? And of course, these people don't have, they're not specialized in the aspect of finance, so they may can contact a finance advisor to come and guide and advise them on the matter. Do you understand? So that's what it means. So interdisciplinary support is a very important aspect. So financial advisor or health, if it's a health matter, do you understand? Maybe there's a health issue that is the problem here. You can seek the counsel of a mental health expert to or a health expert to help you to advise where necessary. Do you understand? So that's what happens. So we are talking about the principles of collaborative law, all right? And one of the principles we mention is that we say it's what voluntary. Another principle we mention is what transparency. Do you understand? And then another principles we mention is commitment to settlement. Everybody is committed to finding a solution to the problem. And then we'll talk about interdisciplinary support, where in case there is a need to seek the the experiential advice from professionals in certain field, you can go ahead and do so. Where you cannot be able to advise accurately and adequately, you can seek the help of professionals in those areas to come and advise. And we mention finance, health issues. Do you understand? Then we talk about mutual respect. You know, the parties must approach the process with mutual respect for everybody, mutual respect for everybody's needs, everybody's interests, everybody's expectations. Do you understand? So it's not just about my expectations, it's not just about your expectation, but the expectations of all of us, the interests of all of us. We want to find a solution that will benefit all of us. Do you understand? So, and that is why it's key that we must work together to find that solution. And in working together, we must work together with respect and and with humility as much as possible, because these are the elements that enhances what collaboration. When you are a proud person, you are so arrogant, you cannot be able to, work collaboratively with anybody to find solution. You just you just think that your own belief and your own thinking and what you want remains sacrosanct, and which is not so. All right, withdrawal clause. Withdrawal clause is also another principle. In case um, the the attorneys or the lawyers, the cooperative lawyers are unable to help the client find a common or a mutual solutions to their needs, what do? They withdraw from that case. They withdraw from that case. In that situation, it means that the parties involved can decide to approach the court of law to seek a legal redress in their matter. Do you understand? So that is what it is. So there's a provisions for the collaborative lawyers to withdraw in case they are not able to find a common solutions for the parties involved in the conflict or in the problem. Do you understand? So that provisions must be there. So basically, we are saying that collaborative laws are those methods or those kind of laws that help clients find solutions to their problem without necessarily going to court. And we say that there are principles that guide this operation. And we say that one of those principles is what? We say one of those principles is voluntarism. There is nobody is under any form of compulsion to compulsion to do it. You come into it willingly. That is number one. We talk about the issue of transparency, where parties share information and document openly without being afraid. We talk about the issue of commitment to settlement, parties working together to find a common solution to their problems. Talk about interdisciplinary support, talk about mutual respect, and we talk about, you know, withdrawal clause, where it's being provided that the attorneys, if they're not able to find a common solutions to benefit all the parties, they can withdraw from that case. Do you understand? So this is one aspect of collaborative law that we have just explained. Talk about the definition. We'll talk about the principles that are involved. All right. So let's look at so we're saying that collaborative law is particularly beneficial in family disputes, all right, such as divorce cases and other personal matters where ongoing relationships are important because it helps to preserve relationship. Do you understand? That's why it's very important because the aim of the whole law is to preserve relationship because those relationships are important. Do you understand? Yes. Imagine you are discussing the issue of divorce. Nobody married to divorce. So when you come to that point, they are very, very serious issues. It's a moment of serious concern. Do you understand? So, and of course, this is the situation where you'll be operating, trying to see that they find a solution to avert divorce as much as possible. So some of these issues may come your way, and to some extent, some may even end. Just they're trying to just see how whether issue of settlement and all of those things will be uh, accommodated, or how children will be taken care of, and all of that will be accommodated. Do you understand? So these are the issues. So let's look at the collaborative processes. What are the collaborative processes? So the collaborative process in collaborative law involves several structured step design to facilitate open communication and cooperation between the parties involved. All right. So let's look at one of those processes: initial consultation. Initial what consultation? The parties must consult with their collaborative lawyers. Do you understand? Their collaborative attorneys to determine whether this matter they have is a matter that they can be able to help them. Do you understand? Or they should go to court straight. If it's a matter that they should go to court straight, the attorney will be able to advise them to. But if it's a matter that can be settled at that level, they will tell them let's give our best and see how we can resolve this matter without necessarily going to court. Do you understand? So initial consultation is one of the things or one of the process that is involved. Then we have signing the participation agreement. Signing what? The participation agreement. Signing the participation agreement. So what this means is that all parties and their lawyers sign a participation agreement. All right. All parties and their lawyers sign a participation agreement. This document outlines the commitment to resolve the issues collaboratively. That is, this document gives everyone an opportunity to understand that as we are going into this process, we are going into it collaboratively, that we are going to work together to find a solution. And if you are not willing, if you are not ready to go into it willingly, you can say that you are not willing. So you cannot go into it. Do you understand? So you have the opportunity to withdraw and then seek other means to address the problem. But once you agree, it means that you are going to cooperate to make sure that the solution is fine. So the document also provides an opportunity for the lawyers so that at the end of the day, if they are not able to find a solution, this document already stated that if they are not able to find a solution, they can withdraw. So they can withdraw and then allow the parties to decide, or they may decide to advise them on the next step to take. All right. So that's the reason why you must sign the participation agreement. That somebody should not come and say that I was forced to enter into it. I was not willing. No, you were not forced to go into it. You came into it willingly. That is the essence why you are signing this document. Sign that I'm participating in this exercise willingly, that nobody is forcing me to do so. You endorse, another person endorse, and so it goes. Do you understand? So that's what it means. So gathering information. Gathering information is also another process in collaborative process. Gathering information. Parties exchange relevant information and documents openly. This transparency is crucial for building trust and ensuring that all decisions are based on complete and accurate what information. So you don't need to hide any information. You don't need to keep one document behind. You have to tender all the relevant document that needs to help in taking an informed decision. So that at the end of deliberations and whatever effort people are making, you'll be able to take informed decision that will benefit all the parties and of course also save their relationship. You understand? So setting goals and priorities. So the parties identify their individual goals and interests because you go into a discussion with a with an interest or with expectations. So these steps help clarify what each party hopes to achieve and facilitate a more focused negotiation process. That's what it means. Do you understand? So that's what it means. So you have to set your own goals. What's your expectation from this issue? What are you trying to achieve so far as this matter is concerned? Another party also sets their own expectations and their goals. Do you understand? And of course, you go into it with that, hoping that you find a common ground where all of you can benefit from it. Do you understand? We have joint meetings. So after setting your goals and priorities, you have a joint meeting. That's you and your lawyers. You come together, you have a meeting to discuss basically maybe the process and then also what is involved, the criteria and the ground rules, as the case may be, and all of that may be discussed. And then you can still go ahead and brainstorm solutions and negotiate terms in a collaborative environment. Do you understand? So that's what you need to do. So we talk about the involvement of other professionals. If needed, you can involve them. All right. So, like we have mentioned earlier, financial advisor or head advisor, they will help. Or maybe you have is an issue that has to do with children, so you have child specialists that may come in to help you to advise or to guide on how the process should go. Do you understand? So that's what it means. So these professionals can help address specific issues and facilitate informed decision making. So that is what they help you to achieve. Then we're talking about negotiating solutions. Negotiating what solutions? Negotiating solutions. Negotiating solutions. The parties work together to explore options and negotiate solutions that meet the needs and interests of all the parties involved. So creative problem solving is encouraged to find mutually satisfactory outcomes. So that is what this particular process helps you to achieve. Do you understand? So negotiating solution, you sit down and brainstorm and discuss and find common solutions for your problem. That the solution that benefits all of you. Do you understand? So we are talking about the processes, the collaborative processes. And we talk about the initial consultation, talk about signing the participation agreement, talk about gathering information, we talk about setting goals and priorities, we talk about joint meeting, we talk about involvement of other professionals, all right? And we also talk about negotiating solutions. So after negotiating solutions, and maybe you have found one, all right, what do you need to do? You need to draft an agreement. Drafting the agreement is also important, right? It helps you to document what you have able to achieve. It helps to document what you have been able to achieve. All right. Once an agreement is reached, the collaborative lawyers draft a formal settlement agreement. This document outlines the terms agreed upon by both parties. Do you understand? So whatever the parties agreed upon is documented in that agreement. All right. And it becomes an evidence that can be tendered anywhere in the court of law and it can be enforceable. Do you understand? So that's what it means. So drafting the agreement, finalizing the agreement. So the finalized agreement is reviewed and signed by both parties. So because after the attorneys draft it, they will come back and read it in the hearing of their parties so that they will know if there's anything that they didn't say and it's in the agreement, they can counter it. You understand? They have it's subjective. Do you understand? So they have reasons to refuse what is being drafted. Do you understand? So if the attorney comes with something and it's not meeting the expectation of, or the party say this is not what we discussed, then there's a possibility for them not to accept it and not to sign the final document. Do you understand? So in family law cases, this agreement is often submitted to the court of law for approval. Do you understand? Ensuring that it is legally binding. So after they are agreed and do everything, and those who sign can be taken to the court of law. Why are you taking it to the court of law? That it must be approved so that it can become legally binding anywhere. Do you understand? So that's what it means. So you need to agree. So post agreement support if needed. So depending on the nature of the agreement, parties may continue to work with professionals to ensure smooth implementation and address any ongoing issues. So post agreement support is very, very important. Do you understand? So after the process, you can still work together to make sure that implementation is done what seamlessly. Because there are sometimes you settle issues, but there may be post uh, resolutions issues. Sometimes there are issues that in the course of negotiation, there may be some issues that may create high tension. Do you understand? And then, of course, you still need to work together to make sure that it's just like when a matter is being settled, but you have to escort somebody so that there may not be a kind of attack again. Do you understand? Something like that. So post agreement support we are needed. We are needed. it must be provided. So collaborative process is designed to be respectful, constructive, and focus on the needs of all parties involved, right? So this is what it means. When we're talking about collaborative process, it has to do with what? Initial consultation, consult with your attorneys to determine whether this case worth going or we should not go. All right. Signing the participation agreement, right? All the parties must agree to engage in this discussion, in this process, and that they are going into it willingly, that nobody is forcing them. Do you understand? That's what we're talking about here. Then gather information so that you can decision taking can be informed. Setting goals and priorities as a person going into any matter, whatever. You must have your personal goals, set your personal goals and priorities. All right. Joint meeting. Involve involvement of other professionals, negotiating solutions, drafting the agreement, finalizing agreement, and post agreement are some of the processes that you need to consider. So let's look at the role of the parties and the role of the attorneys so far as collaborative law are concerned. Let's look at the role of the parties and the roles of the attorneys. So first and foremost, we are going to look at the role the attorneys play, the attorneys, play so far as this matter is concerned. You hire an attorney. What do they expect to do? What are they going to do? Do you understand? What are they going to do to help you to get out of the mess you find yourself? So let's look at the roles of the attorney. All right. One is facilitators. They serve a role of what? Facilitators. Attorneys serve the role of what? A facilitator. You understand? So the attorneys guide the collaborative process, helping to facilitate discussion and negotiation between the parties. So that's what they do. They create a respectful environment conducive to open communication. So that's what they so that you are not shouting at anybody in the course of conversation. You are not saying stop or you are not interrupting anybody. That is why they are there to facilitate. So they play that function, they play that role. Do you understand? Then we'll talk about advisors. So they also play the role of advisors where necessary they advise, okay, don't take this action or don't go to court or go to court. Do you understand? Because we cannot be able to. And this is how you go about it. All right. You get a lawyer who would recommend one for you and all of that. Negotiators. They also play the role of negotiators. The attorneys advocate for their clients, okay? They advocate for their clients, all right? And the interest of their clients. Do you understand? So that's what they do. Yes, that's what they do. So they negotiate. So they negotiate with high concentration. Do you understand? Highly concentrated. So they help negotiate terms that align with clients' goals and the overall collaborative spirit. So they also educate. They play the role of educators. Do you understand? Where the client doesn't have certain knowledge, the attorney's job is to what? Educate, 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 educate. All right. So drafting agreement, drafting agreement, drafting agreement. Once an agreement is reached, attorneys draft the settlement document. Do you understand? They're the ones that draft it. It's not the parties. It's not their client. It's the attorneys that draft the document. Do you understand? And then because they are going to draft it in such a way that it can be approved. Because at the end of the day, they are going to submit it to the court for approval. Do you understand? So they will draft it in such a way that it will be in accordance with what the law says. Do you understand? So that it will not be rejected at the end of the day. So that's why they have to draft whatever agreement that has been reached. Do you understand? Maintaining ethical standards. The attorneys also uphold ethical obligations because whatever that they may do that is not in line with their profession and their also reputation and integrity, It means that it's going to affect their tomorrow. So they have to maintain high level standards. Do you understand? Then we'll talk about role, the role of parties. What is the role of parties in this situation? Active participants. They are active participants, they participate actively. Do you understand? The parties participate what actively to make sure that um, whatever that is expected of them, they are meeting up, right? They participate in attending meetings and they attend to discussions and negotiations. Do you understand? Their involvement is crucial to finding a mutually satisfactory resolution. Very important. So that's why they must come because there's what we call co-production. Do you understand? In customer service marketing, we talk about co-production, where the customer collaborates with the service providers to provide solution. Do you understand? So this is what it is here. So the parties must involve and participate adequately to find a common solution to their problem. Open communicators, they are also playing the role of uh, providing relevant information and documents, transparently. Then identifying interest. Identifying interest. Each party is responsible uh, for clearly articulating their needs. All right. So it's left for you to say what you want or what's your interest. If you do not say what you want or is your interest, nobody can jump into your mind and know what is running in your mind. Do you understand? So that's why you must say what is your interest. So identify those things that are your needs, are your interests, and are your goals, so that while you are going into the discussion, that will guide you and guide how you take steps regarding those matters. So this self reflection helps guide the negotiation process. Helps to guide what negotiation process. So collaborative mindset from the beginning, all the parties must position themselves to collaborate to make sure that they work together to find a common solution. It's a very important matter. So that process that has to do with spirit of cooperation must be included. It must be embedded so that they will focus on the solution that benefits both parties rather than doubting any adversarial stance. So another rule of parties that are involved in this is commitment to settlement. They must work together to provide solutions. That's the role they play. Commitment to what settlement. They work together. They must work together to provide resolution. Respectful interaction. Parties are expected to treat each other with respect, maintaining a focus on constructive dialogue rather than conflict. Do you understand? So, in wherever you find yourself, whatever situation you find yourself, all right, respect one another. It doesn't matter your level, whether you are so classic or you have everything, you don't need anybody um, concern, but you must, as a matter of fact, respect so far as that discussion is concerned, respect the other party's opinion and interest as well. Do you understand? So it's very, very important. So in a situation whereby you're going to negotiation, don't look down on anybody. Don't look down on anybody. It may surprise you that it's the person you are looking down on that may challenge you and then you get confused. Do you understand? So implementation of agreement. So after reaching an agreement, parties are responsible for fulfilling their obligation as outlined in the settlement. All right. So the settlement may specify what Party A and Party B should do to make sure that this resolution is implemented. So they should be aware. It's not something that they will be ignorant about. They should be aware. You understand? So that you can be able to maintain a high sense of accountability. You understand? So that someone can ask you what has happened, you'll be able to say what has happened. Do you understand? High sense of accountability. So the collaborative process is built on the active participation of both the attorneys and the client. Do you understand? So they must be involved in it. They must contribute effectively. So that is what it means. They must contribute effectively. I hope you are following me. Are we together? Let me know that you are following. All right. So that is it. So those of you that are just joining us late, we say that if you participate in the emotional intelligence training, we have provided instruction on how you are going to get your certificate. So try as much as possible to follow the instruction. Do you understand? Try as much as possible, listen to the and the audio, and then take follow the instruction the way it has been provided, so that you can be able to get your certificate. Do you understand? And then um, for those of you that did not pass the exams, yes, you are going to write your exams on the 25th. So prepare yourself that you're going to write the exams on the 25th. Yes, do you understand? So try as much as possible to do that. Prepare. We want you to write on the 25th so that you can have time to prepare for this one, for your exam for this one, because this one will be coming first Saturday of what do you call it, of October. So do your best to clear this one so that you can face the one that is coming up. Do you understand? So it's very, very important. Yeah. Are we together? So if I get to share the meeting with somebody, share, invite them to also participate in this training. So just share to someone, invite them, call on them, just put it on your wall, inviting all your friends and your followers to join and participate in the training. It will help you and it will also help them. You understand? So um we are going to look at the last topic for today, and we are looking at benefits and challenges of collaborative law in family and business disputes. Benefits and challenges of what collaborative law in family and business disputes. So, collaborative law offers several benefits and challenges for both the family and business disputes. Do you understand? So, it's better for you to understand the approaches to finding common solutions to the problems. Well, let's look at some of the benefits of family uh, disputes. What benefits collaborative law brings in family disputes? What benefits collaborative law brings into what family disputes? So let's look at it. One is preservation of relationships. So the whole essence of collaborative law is to preserve relationships. And that's what we say either business or family affairs. Do you understand? These are relational problems. Maybe so when you are in a business relationship with someone, you see how it is. So you wouldn't want to end the relationship. You wouldn't want a situation whereby once friends become enemies. Do you understand? So it is not good. It's not good, and that's why you are looking for a family lawyer to help you resolve this problem. Do you understand? So that you and the friend and the person can still continue as friends, as family members, as business partners, all together. So that's what it means. So preservation of relationship is key, and collaborative law emphasize so. Do you understand? So control over outcomes. Parties have great control over the resolution process and outcomes compared to traditional litigation. So that's what it is. So the parties involved in collaborative law have total control over the process because the lawyers are not going to take the decision for them. They are there just to facilitate and advise where necessary, but they cannot take decisions on behalf of the people involved. Do you understand? So that is what it is. So control over what the outcome. So the parties have total control of what becomes of the process and what could be defined as the outcome of the process. They have total control. Do you understand? So that's what it means. So the parties, when going into it, they are prepared because they contribute to provide the solution. So they must take ownership of the solutions. Do you understand? They take ownership of what becomes of that process. So let's look at emotional support. Emotional what? Support. So collaborative law can be less costly. Oh, sorry, it can encourage what? Open communication, reducing hostility and emotional strain, which can be what? Beneficial for all parties involved. You know, it's possible that the issue, even family issues, there's hostility. Do you understand? Where somebody will be shouting, ah, I am the first child of this family, so I should take the lion's share. Oh, as our father is no more there, I am the one that is in charge. I should be the one to be in charge, and I'm not going to share anything with anybody. I will continue to take charge, and then I will take care of you. Do you understand? So there's that kind of, so there may be tension, and they are arguing and quarreling, and all of those things. So there should be what? Emotional support where necessary. And then talk about effective cost effectiveness. Cost effectiveness is also another benefit of what? Collaborative law, right? When it comes to family dispute, cost effectiveness. Collaborative law can be less costly than litigation due to a focus on what? Resolution without prolonged court battle. So it saves you the money that you'll be going to court every day. You'll be paying a lawyer's appearance, you'll be paying this one and paying that one. Do you understand? So it saves you that money. Do you understand? So confidentiality. Confidentiality is also one of the benefits when it comes to family disputes, and that is what uh, collaborative laws offers you. Confidentiality. It benefits you in family disputes. It maintains high level of secrecy. You understand? High level of what? Secrecy is being maintained so far as family dispute is concerned. So the collaborative law keeps your secret. All right, they keep your secret. So what are the benefits of collaborative law in business disputes? We have relationship maintenance. It helps you to maintain relationship. You may have business disagreement, you may have dispute in the course of doing your business. But what happens? This particular law help you to preserve relationship. Do you understand? It maintains relationship, all right? Creative solutions, creative solutions. That is, parties can explore innovative solutions that a court may not be able to offer, allowing for more flexible and creative outcomes. So that is the crux of all the matter. Do you understand? So parties can work together to find a solution to their problem. Parties can work together to uh, find creative ways of resolving their problem instead of going to court to file a litigation that will take them months, years to complete. And then, of course, at the end of the day, create enmity. But this one provides opportunities for you to continue as business partners, all right, while you solve your problems. Efficiency. The process can lead to quicker resolution of course, reducing the time spent and the amount of money to be wasted. Do you understand? So efficiency is also one of those benefits of collaborative uh, and the collaborative law brings into what business dispute resolution. We'll talk about reduce adversarial tension. So the tension between the parties or among the parties is being reduced because of what their willingness to come together to solve their own problem. So they come together, they are reasoning together to solve problems. So of course, it will reduce the tension, all right, and then focus on future collaboration where necessary, where there is a need tomorrow to work together again to find solutions to problems. You go ahead and work together to find solutions to your problems. Do you understand? So, but there are those kind of chances that you still have to work together. You don't know when there may be business disagreement again, and then you have to work together to find solutions to your problems. So let's look at some of the challenges that uh, may likely confront collaborative laws when it comes to family disputes. What are those challenges that may likely confront uh, collaborative law when it comes to family dispute? One is emotional barriers. Emotional barriers. High emotions can interfere with constructive communication and negotiation, making collaboration very, 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 very difficult. Am I your mate? Look at this small boy. I'm not going to take that shit from any of you. Do you understand? I'm not. I cannot sit with you and discuss our family heritage. I am, so far as I am concerned, I am the head of the family. I am the eldest son, and so I take charge. So I will take care of you. And then those ones say, no way. We must share our father's inheritance. Do you understand? So there may be so much argument and tension. Do you understand? And this can bring about what? Emotional barriers. So they may not be able to reason very well and behave in calmness to solve problems. Most especially if they lack emotional intelligence. Do you understand? If they lack emotional intelligence, what will happen? They will not be able to solve the problem. Rather, they may end up, if care is not taken, they may end up killing themselves. Have you not heard, or even some of you who seen, we have such kind of crisis consume the whole family? They started dying one after the other, and all die. The properties they were fighting for, none. Take it. All die, left it behind. Do you understand? So that's what it means. So emotional barriers. There can be instant or emotional barrier, and of course, that will affect the collaboration process. Do you understand? Then power imbalance, where one party is stronger and better positioned than the other party, then this can be a challenge. It can be what? A challenge. Can be a challenge. Communication or commitment to process, rather. Commitment to process. Both parties must be genuinely committed to collaborative process. That is, you must, if you say you are going to do something, be genuine about it. Some of you, so far as you have made your mind that you are going to participate in this training, you always join. Some of you that, those of you that join on YouTube, you always join before the meeting starts. You understand? You always join before the meeting starts. So that's why this commitment, so to process, commitment to process. Both parties must genuinely committed to collaborative process. And lack of commitment from one side can undermine the effort. Of course, in any team spirit, once one team member is not cooperating, it becomes so frustrating. Do you understand? So that's what it means. So withdrawal from process. Withdrawal from process. The parties can withdraw, the attorneys can also withdraw if the matter is not going as expected. They can withdraw. So these are the challenges that collaborative law may likely face in what family disputes. Let's look at what um, uh, collaborative laws may face in business disputes. Complexity of issues. Complex issues may need to be addressed. Business disputes may involve complex legal and financial issues that require specialized knowledge, complicating the collaborative process because you may need to hire a financial advisor to come and give it advice. Do you understand? So all of those stuff. And then we'll talk about risk of non-compliance. Risk of what? Non-compliance. Maybe after the process, and you have agreed that this is what you're going to do. At the end of the day, one party may be unwilling to comply with the implementation. You know, so it can become a problem. It can become a problem. The risk of non-compliance in business is a problem. What if we reach an agreement with someone and then of the day you're not hearing from them? They refuse to work on it. Do you understand? To work on it. So it becomes a problem. So confidentiality concerns how trusted are these parties and how can they keep the secret? Do you understand? How can they keep the secret? So parties may be concerned about whether parties will adhere to what we adhere to the relevant agreement reached or not. So it's a matter of concern. Do you understand? As soon as the people involved are not trusting one another, it's a matter of time. The process will collapse. You understand? So potential for unresolved issues. Potential for what? Unresolved issues. So whatever issue that needs to be resolved should be resolved. Don't need to keep it. Whatever issue that needs to be resolved must be resolved immediately. So these are some of the challenges that collaborative law may face in business dispute. Do you understand? So collaborative law can be an effective approach for resolving family and business disputes, offering numerous benefits, particularly in preserving relationship and promoting creative solutions. So that's some of the things. And this is the much we can take for today. I really appreciate you for taking your time to be part of this today's training. And I hope you have learned something. I hope you follow well. And I hope you have learned something. So what do we do? Continue to run with it. And like I said, this week is tomorrow is our peace walk. And if you are not going to join us, do something in your community to celebrate peace. If there's no peace, we cannot be doing this training. Do you understand? If there's no peace, we cannot be doing this training. And where they are not having peace, we will make noise until they get there and they begin to have peace. Do you understand? So it's very important. So let's work together to make sure that we find a common solution to some of these things. So do your bit, do your small. Let another person do his or her small, and then it becomes a bigger one. So for peace, do something this week. Tomorrow, do something in your community. I'm expecting to see something that you will do. Some of you, and if you have done something, send it to us so that we can see to it. So thank you very much. We appreciate your time and your contribution. And if you have any challenge regarding the download of the certificate, let us know first. So, but don't go and do something that will put you into jeopardy. Do you understand? Have a wonderful night rest. I will see you tomorrow by 7 p.m. after our peace walk in Abuja here. So, uh, so those of you that are in Abuja, please try and come out so that we'll be part of the process, and then you'll be promoting peace together. Thank you, and have a wonderful, wonderful night rest. All right, bye.